My name is Savannah Griesinger, and I'm the Director of External Relations at FedSoc. Thank you so much for joining us today. This discussion is going to be about the most recent Supreme Court term, and as you all know, this term featured several landmark cases regarding admin law, First Amendment, election law, federalism, the separation of powers, and much more. Our panel discussion today will highlight some of this year's important cases and what they mean for Congress. And I'm going to introduce our moderator briefly and then hand it over to him to get the panel started and introduce the rest of our speakers. I will note that we do have a time for question and answer at the end, so please hold your questions until then. And please, if you do ask a question, make it a question and not a monologue or a soliloquy. So, our moderator, Judge Trevor McFadden, was appointed to the U.S. District Court for the District of Columbia in 2017. He received his bachelor's from Wheaton College and his JD from the University of Virginia, where he graduated Order of the Coif and was editor of the University of Virginia Law Review. After law school, he clerked for Judge Stephen Colton on the U.S. Court of Appeals for the Eighth Circuit, and he joined the U.S. Department of Justice, where he served as counsel to the Deputy Attorney General and Assistant U.S. Attorney in the District of Columbia. He later was a partner at Baker & McKenzie, where he focused on white-collar investigations. And after 4 years in private practice, he returned to the Department of Justice as the Deputy Attorney General and the second in command of the department's criminal division. As Deputy Attorney General, he managed the division's fraud and appellate sections. And he also has extensive experience in law enforcement, where he served as an officer in Fairfax County, Virginia Police Department and a deputy sheriff in Madison County, Virginia. With that, I'll hand it over to the judge.
Thanks, Savannah. Such a pleasure to be with you all today. Great lunch and fun to be all together on this very hot day. If we start by thinking back to a year ago, what people were talking about with the Supreme Court last summer, the court had just hit the brakes on the affirmative action in SFA versus Harvard, canceled student loan cancellation in Biden versus Nebraska, and rejected the independent state legislature theory, Moore versus Harper. After such a big term, some wondered whether OT 23 wouldn't stack up. After all, that case about the fish was supposed to make most of the headlines this year. In other words, it was expected to be something of a sleeper term. Well, the fish case certainly made a splash with the Supreme Court formally Did you like that? Yeah, thank you. Thank you.
Starting off strong.
The Supreme Court interred the Chevron doctrine in Loper-Bright, but last term gave us much more than that. The Trump docket sprang back to life with ballot eligibility in Trump versus Anderson, presidential immunity in Trump versus United States, and indirectly with Fisher versus United States, dealing with obstruction of an official proceeding, charges in the January 6 cases. Agency power came under scrutiny. One got a green light on its structure in the CFPB case. Another was forced to yield to the Seventh Amendment in the SEC versus Jarkissi. Social media outlets made and largely won their First Amendment arguments in Murthy and NetChoice, and guns featured prominently in Rahimi and Cargill, although sometimes in ways that you might not have expected, such as in NRA versus Vulo. In some, it is now being heralded as one of the most consequential terms ever. These cases have a particular salience for Congress and those who work for Congress or with Congress, as many of you do. For some cases, as in Loper-Bright, the impact may be immediate. For others, the implications may be more remote. We have a wonderful panel here to talk about these cases and what they might mean for you all. I'll start on my right, your left, with John Elwood. He leads the appellate and Supreme Court practice at Arnold and Porter. He's argued 10 cases before the Supreme Court and has appeared before most of the federal courts of appeals. I hear he's hoping to get to appear before some district courts in the future. His success as an advocate spans many sectors and subjects, from environmental and administrative law to the False Claims Act and federal criminal law more broadly. Before private practice, John served as an assistant to the U.S. Solicitor General and as a senior deputy in the Office of Legal Counsel and at the Department of Justice. He also clerked for Justice Kennedy back in OT 1996. Jen Mascott, to my immediate right, recently joined the Columbus School of Law as an associate professor and director of the Separation of Powers Institute. Professor Mascott teaches and writes on administrative and constitutional law, theories of interpreting legal texts, and the separation of power. Her scholarship has been cited widely and published widely by a variety of outlets and receives extensive citations from the Supreme Court and lower courts too. She serves as a Supreme Court contributor for NBC. Professor Mascott joined Columbus Law from the Antonin Scalia Law School, where she was a professor of law and co-director of the C. Boyden Gray Center. Before and at times during her career in academia, Jen has held numerous positions in federal government. She was the Deputy Assistant Attorney General in the Office of Legal Counsel, and then simultaneously picked up the role of as Associate Deputy Attorney General. Door prizes later for those who can distinguish between a DAG and an ADAG. Before all this, Jen clerked for Justice Thomas and then Judge Kavanaugh on the D.C. Circuit. Next is Mark Chenoweth. He serves as the President and Chief Legal Officer for the new Civil Liberties Alliance. But before his current post, he observed the administrative state up close and personal from perches in all four branches, and air quotes around four there, of the federal government. Mark served as the first Chief of Staff to Congressman Mike Pompeo, as legal counsel to Commissioner Ann Northup in the U.S. Consumer Product Safety Commission, and as an attorney advisor in the Office of Legal Policy, U.S. Department of Justice. Previously, he was a law clerk for Judge Danny Boggs on the Sixth Circuit. He's worked in several different roles in the private sector as well. He began his legal career at Wilmer Cutler. He returned to his home state of Kansas to serve as in-house counsel for the Koch Industries, and he recently spent over 4 years as general counsel of the Washington Legal Foundation. And last but not least, we have Matt Stoller. He's a public intellectual who writes about the American anti-monopoly tradition. And I just want to say, there's a number of cool titles up here, but public intellectual is the best. He currently serves as the Director of Research at the American Economic Liberties Project. A few years ago, Matt authored the book Goliath, The 100 Years' War Between Monopoly, Power, and Democracy. Business Insider called it one of the year's best books on how to rethink capitalism and improve the economy. And FTC Chair Lena Khan said the book couldn't be timelier or more relevant for current debates around the dangers of unchecked corporate power. Matt's expertise on monopolies traces to his deep experience on the Hill. He formerly served as a policy advisor to the Senate Budget Committee, and he worked for a member of the House Financial Services Committee during the financial crisis. Since then, he's written several influential articles, lectured at top academic institutions, and created the monopoly-focused newsletter Big, which now has over 100,000 subscribers. All right, so we're going to start off by asking each of the panelists to briefly describe a few of these key cases from the last term. Then we'll have more of a discussion amongst the panel about the implications of these decisions, and especially with a focus on implications for you all in the first branch. And then we'll wrap up with some Q&A from you. So John, maybe we could start with you to summarize a few of those big cases.
Sure, thank you very much. So I have the Trump docket, although it's a slightly different one than Judge McFadden mentioned. First, a case involving the Trump tax cuts, the ballot access case, and the immunity case, which I hope to wrap up in about 8 minutes. So first of all, Moore versus United States. So to offset the Trump tax cuts, Congress enacted a one-time backwards-looking tax on earnings retained overseas by American-controlled foreign corporations. I will try to speak as slowly as I can because this is the densest of the 3 cases I will be talking about, to address trillions of dollars that were sloshing around overseas and hadn't been repatriated because people were trying to avoid taxes. So Congress enacted a pass-through tax that would basically tax American shareholders in foreign corporations, small corporations. So a company brought a constitutional challenge to that tax. It lost on the way up to the Supreme Court. It got to the Supreme Court and they took it. It was much hyped because a lot of people thought that this would be the Supreme Court passing on the constitutionality of a wealth tax that Elizabeth Warren is always talking about. And so it was closely watched and it was decided very narrowly by a bare 5-4 majority, technically 5-2 to 2 majority. Justice Kavanaugh and the Chief Justice, joined by the 3 liberals, said it was constitutional, essentially by analogy to partnerships, S corporations and F corporations, that it was basically okay it was realized by the corporation and it was okay to attribute it to one rung down to the taxpayers. There was a lot they didn't decide. They said we don't address the distinct issues of taxing on holdings, wealth, or net worth. There's also a big asterisk about due process challenges to attribution rules. Justice Barrett, joined by Justice Alito, concurred basically only because they said this is indistinguishable from F corporations, and the challengers didn't challenge F corporations, but they said it was an open question whether taxation of F corporations was even constitutional. They were obviously very skeptical of this idea that you could attribute to taxation to individual shareholders. Justice Thomas, joined by Justice Gorsuch, said they just plain out dissented and said realization is a constitutional requirement and this attribution doctrine is an unsupported invention. So a very near thing. Next up, plenty of time. Trump versus Anderson. Hopefully I didn't lose anybody there, but it becomes more comprehensible from there. So a group of Colorado Republicans and independents sued in September 2023 to have Trump taken off the Colorado ballot, saying he was ineligible under Section 3 of the 14th Amendment, which says that no person shall hold any office under the United States or any state after you've taken an oath and engaged in insurrection. But Congress may, by a vote of 2/3 of each house, remove such disability. So a Colorado state judge held a trial and said Trump engaged in insurrection, but that the presidency isn't an officer of the United States, so there's something to disagree with for everyone in that decision. And the Colorado Supreme Court reversed by a 4-3 vote and said Trump should be removed from the ballot. The court took the case. It was argued and decided fairly quickly in a unsigned per curiam opinion that I think was probably written by Chief Justice Roberts by the tone of it. 6 votes for most of it, 5 votes for the broadest ruling, or I guess 5 votes, well, anyway, you'll hear. Everyone agreed that states can disqualify people for the state ballot. Everyone agreed that states cannot disqualify people on the ballot for presidency. 5 votes, meaning essentially all the male conservatives, said that essentially, in order to disqualify candidates for federal office, Congress has to enact implementing legislation. The dissenters, the liberals, dissented and said that the court decided more than they needed to. They should have just decided the presidency and not weighed in on other federal officials. Amy Coney Barrett agreed in a more pleasant manner, saying we should reduce the temperature, not raise it, but said everyone agrees on the bottom line there. So there's that. Third, Trump versus United States. I don't know if anyone's heard about this, so I'll go into this a little bit more detail. No. It arose out of Special Counsel Jack Smith's prosecution of former President Trump for conspiring to overturn the results of the 2020 election. Trump alleged he had absolute immunity. It was rejected by District Judge Tanya Chutkan and a panel of the D.C. Circuit. And the Supreme Court vacated and remanded by a mostly 6-3 vote. The opinion to me echoed a little bit Justice Jackson's concurring opinion in the Steele seizure case. There, the tripart thing was, President acts essentially alone, President acts with Congress's support, President acts with Congress opposed to him. But here the question was, or the tripart thing was, official acts where the President has exclusive and preclusive authority under the Constitution, all other official actions, and unofficial actions. It relied very heavily on the Nixon tapes case, executive privilege, and Harlow versus Fitzgerald, where the Supreme Court held that the President had immunity from civil actions based on acts taken as the President. It held that for acts entrusted to the President alone, such as the pardon power and removing and supervising his close political appointees, he had absolute immunity. So, okay to threaten to remove the acting AG. It's okay to talk to the DOJ, absolutely immune for that. I think ordering sham investigations, also okay, or also absolutely immune. For other official actions, had presumptive immunity to the outer perimeter of his official responsibilities. That's the quote. The presumption could be rebutted if the prosecutor shows that the prosecuting it wouldn't intrude on the federal power of the executive branch. And the court really didn't decide anything which is to be expected. They usually don't apply the rules that they set out. You would have thought maybe they would make an exception in this case, given the shortness of time, but they didn't. But they kind of, hinted at it, but nothing all that dispositive. Amy Coney Barrett went farther. But they suggested that perhaps pressuring state officials to find votes and pressuring the vice president might overcome the presumptive immunity because the vice president is acting in his office in the fourth branch or whatever as a legislative official. And acts in not an official role are not immunized and raise the question, the majority raised the question whether speaking in public or tweeting would be covered, but left all that for the district court. Speaking to the January 6th crowd as a private citizen or a campaign mode, not immunized. Like many immunities, it has to be resolved pre-trial. And this is the part that split the conservatives. He said that the per curiam said evidence of the president's motivation for his official acts could not be considered. So you can't get privileged documents. You can't get privileged documents. You can't get or can't introduce private conversations. Justice Barrett disagreed with this part, so it was only 5-4 there. She disagreed with some of the other analysis and kind of fine points, but that's the broad sketch. And in a footnote responding to Justice Barrett, teasing this out, the majority made clear that prosecutors could introduce evidence of official acts, but just through, other evidence of that, not through private conversations and things of the sort. So having taken so long to resolve the case, relatively speaking, given what was going on, there wasn't much said by the majority about what was covered, what wasn't covered. There was a lot more hinting in Justice Barrett's, or a lot more analysis in Justice Barrett's concurrence. Justice Thomas wrote a separate opinion questioning the constitutionality of the independent counsel, both because Congress hadn't acted and because he wasn't Senate confirmed. And then the liberals dissented in an opinion by Justice Sotomayor that was pretty fiery. So, and we will revisit the implications of this later.
Thank you.
Sorry for going so fast.
Thanks, John. There's a lot to cover there. So moving from the evergreen Trump docket into the agency docket. Jen, start us off.
Well, first of all, it's really an honor to be here. I think it's great to have gathered folks who are tied to the Hill to be thinking about the implication of the Supreme Court decisions. And obviously, the legislative branch is really where the law and policy historically is supposed to happen. And honestly, the executive branch has hundreds and even thousands of lawyers. You can hear that from the fact that virtually all of us up here have had former executive branch legal experience figuring out how to increase the efficiency and effectiveness of executive power. So it's fantastic for folks in the legislative branch to have outside legal support. And to that end, not only here at this event, but just recently with moving to Catholic, also started a foundation, the Constitutional Renewal Foundation, to try to provide some educational study and support on some of these separation of powers issues to policymakers. So if there are follow-up questions, hit us at jen@constitutionalrenewal.org. And just to get to the cases today, I know that Judge McFadden is really emphasizing how this was still such an impactful term, and it was because, of course, the court was having to hear a lot of these impactful cases dealing with presidential power. Although, on the other hand, I think one theme from this term as well is that a number of the alliances were surprising, and with all of the constitutional big questions that came up to the court, it actually is quite remarkable how many of them they turned away or said, no, there's not a constitutional problem here, or the case was decided on either a statutory or jurisdictional basis, meaning the court, for example, in the Mifeprestone case dealing with the abortion pill, said there's just no power for us to hear this case because there's not a concrete injury, and that was remarkably a unanimous decision. So contrary to what we might hear when we're hearing from folks who are concerned about the District of Florida's recent dismissal, Judge Cannon's dismissal of the indictment, and the court's decision on its final day on presidential immunity, it really does not appear to be a court that's reaching out to intentionally come up with controversial decisions. So how do my cases I'm talking about stick with this theme? So I'm talking about Rahimi, which is the gun case, right? So we know in the Bruin decision from a couple years back where the Supreme Court say, yes, the Second Amendment's still a thing, we're going to protect it. We've got to be looking historically at how broad the protections are for gun rights. But in Rahimi, essentially the court said, we do not think that the historical scope of Second Amendment rights means that there is a lack of power to restrict gun ownership, at least temporarily, for people who have restraining orders against them and have engaged in domestic violence. So there's some real limits being put there. The court's trying to work out a little bit more as a methodological matter how it's going to apply the Second Amendment moving forward. But it was basically an 8-1 decision, still applying a historical test, still looking for history and tradition, looking for it a little bit differently in the Second Amendment context. So this is something to be aware of. In the past, the originalist justices, a lot of times were looking for, is there a history of protection of a right? The court said no in the Dobbs decision 2 years back. There's no history of protecting a right to abortion. In the gun and the Second Amendment space, the text actually operates in sort of a converse or a flip fashion where the court has said we're going to actually look for a history of regulating firearms in this fashion. So instead of looking for the history of the size of the right, they're looking for a history of governmental power. And if they don't see a history of regulating firearms or an analog to that, they're not going to conclude that governments today have power to issue these regulations. So they said, New York, you went too far in Bruin. This time, the majority of the justices thought that there was a history, at least, of different common law causes of action being used at the time of the founding to restrict gun possession and use by people who had a history of violence. Also notably for people who are thinking about this from a strategic side, the government here was involved in a case where we really had one of the least sympathetic defendants that we possibly could have. This was not just some hapless person who was maybe engaged in some questionable, controversial, we don't know he said, she said kind of a matter. He had multiple historical instances of a lot of violence. So the very person that everybody might agree, we certainly wouldn't want to meet them with a gun on the street, whether or not we think they have a right to have it. So Rahimi's an example of reversing the Fifth Circuit's determination that this was protected by the Constitution and that the federal government doesn't have the right to regulate guns in this space. Another rejection of the U.S. Court of Appeals for the Fifth Circuit's constitutional determination is in the CFPB versus Community Financial Services Association's case. That's a 7-2 decision written by Justice Thomas, not a historic defender of administrative power for power's sake. So again, I think another instance where we see justices across the spectrum trying to apply the law and the Constitution as they see it. So a lot of times when we get constitutional challenges, we're looking for the affirmative existence of a right, or we're looking for whether Congress affirmatively has power in Article 1, Section 8 to do things. This case involves a different section of Article 1 that we don't necessarily pay attention to as frequently, Article 1, Section 9, which lists a number of things that the government and in particular Congress cannot do, or limits on what it can do. And in here, there can't be an appropriation drawn out or used unless it's done in coming out of the Treasury, unless it's done in consequence of an appropriation made by law. So by statute. So what does that mean? So probably many of you here know that Congress not too many years ago, in establishing the CFPB, gave it a unique funding stream. Instead of having to go through the annual appropriations process and your bosses look year by year whether it's spending its money properly, how to peel it back, we decided it was a really trustworthy agency that would do only modest, uncontroversial things, and that surely we should leave it up to the director to decide how much money he or she needs and go to the Federal Reserve and just sort of siphon it off every year. Whether that's good policy or not, that is fantastically a decision for many folks in this room and your bosses and people across the street to make, and is worthy of, I think, a lot of evaluation. The court had framed to it a different question. Does that type of law, saying by law that the CFPB director can go to the Federal Reserve up to a particular point each year and say what money is needed, does that violate this restriction that you can only spend money in consequence of an appropriation made by law? And Justice Thomas, writing for the majority, said, we don't historically, textually, under original public meaning, whatever interpretive theory, see evidence that this prohibition required a particular fashion of lawmaking. The law doesn't specifically have to give appropriations year by year. In fact, we have a competing provision that says you can't have a standing army that's funded for more than a 2-year-long appropriation. The implication there is other appropriations can be done indefinitely, and it's sort of, I mean, whether folks want to debate that or not, that's the Supreme Court's current determination. Interestingly, the appropriations claim, I don't know if it'll come before the court again, because I don't know if folks had a chance to work their way through Judge Cannon's dismissal yesterday of the special counsel indictment, but she determined that the special counsel position is not adequately created by law under the Appointments Clause, and she said, therefore, this is actually another violation of the Appropriations Clause, because since the Special Counsel Office wasn't established by law, there's no law authorizing the appropriation for it either. So it's a slightly different version. I'd say it's one step closer to the Justice Thomas CFPB idea. If that makes its way through the 11th Circuit and up to the Supreme Court, we'll see if the court is persuaded by that Appropriations Clause argument. I don't actually think it's really an Appropriations Clause challenge. I think it all circles back to the question of, was the Office of the Special Counsel established by law? But you see some of these issues recurring and overlapping. Okay, so what's the one constitutional claim that the court did grant? They had 3 to look at in SEC versus Jarkissi, again from the 5th Circuit. Are the judges within this SEC unconstitutionally protected by tenure protections? Are they free of supervision? Are they delegated too much power? The court said, we don't have to mess around with that, because we can tell that in this particular case under the Dodd-Frank legislation, that the SEC was given the power inside its own walls to decide and adjudicate and impose penalties for people charged with securities fraud. And guess what? We have a 7th Amendment. We've got jury trial rights. Those are historic. Those apply to all cases that were brought before a jury at common law. The SEC cannot adjudicate these cases. They have to go before Article III courts, where one can get the protection of a jury. So this is a massively important area that actually, I think, really immediately could lead to concrete follow-up in congressional offices and committees. Looking through, there's already interest in this with the House Judiciary Committee having a subcommittee hearing on agency adjudication earlier this spring, at which Mark and I testified. And there was actually bipartisan interest on both sides, looking at how many administrative law judges would have to be replaced by Article III judges to actually get a lot of these claims and similar ones handled the right way, even as a policy matter. The answer is not that many. It's like a couple dozen administrative law judges who are doing the most egregious or powerful things. And so it could really re-examination of some of this newer legislation, in particular Dodd-Frank Act and some other statutes authorizing a lot of agency adjudication, whether before FERC or the CFPB or whatever, could go through and see, should this be better brought in an Article III court system where we don't have an agency system in-house writing the regulations, i.e. sometimes the law, investigating and bringing the charges, and also adjudicating them and being judge and lawmaker within one set of laws, which is the complete opposite, some would think, of the separation of powers established by the Constitution.
Thanks, Jen. All right, continuing with the agency docket, Mark.
That brings us to the fish case, or as I like to call it, Chevron sleeps with the fishes. Had to do it, Judge, since you went there. So I'm going to talk about three cases, Loper, Bright, and Relentless, which is really the same case, Murthy and Cargill. And the good news is that Insula brought all three of these cases. The bad news is that we only won two of them. We won both of them where we got to pick who argued. We lost the one where we didn't get to pick who argued. I'm not saying it would have made a difference, but when we get to Murthy, I'll say, look, if you're going to kick my client out on standing, I'd sure like an opportunity to be up there for oral argument to explain why my client has standing. But we'll come back to that. Let me start with Loper, Bright, and Relentless. So for those who don't know, they're two separate cases, exact same issue under the Magnuson-Stevens Act. The Loper, Bright case came up through the D.C. District Court and D.C. Circuit. The Relentless case came up through the District of Rhode Island and the First Circuit Court of Appeals. But the question in both of them had to do with whether these human monitors on board herring fishing vessels have to be paid for by the government, or whether the government, specifically whether the agency, not Congress, whether the agency can force the boats to pay for those onboard monitors. And the answer at both in both the D.C. Circuit and the First Circuit was yes, because it's a reasonable interpretation of the statute under Chevron to say that you can do that. Now, I thought that was an interesting thing for those courts to decide, because what the statute actually said, what Congress actually said was you can make foreign vessels pay and you can make vessels in the North Pacific pay. That's it, right? Well, herring fishermen in the North Atlantic are not foreign and they're not in the North Pacific. So it felt to us like these judges maybe had a geography problem. But what they really said was, look, under Chevron, if there's a gap or an ambiguity in the statute, then we're going to defer to the agency. And the agency said, look, there's a gap in the statute. It doesn't say specifically what happens in the North Atlantic, so we're going to read that to empower us. And the court did not grant that statutory interpretation question, even though both Loper, Bright and Relentless asked for that. It only granted the question of whether or not to overturn Chevron deference. And thankfully, the court did do that. And I think this is a massively important case. It levels the playing field. Anybody who's being sued by an agency or who is suing an agency now has the ability to have an independent judge actually decide their case. There's no longer a thumb on the scale. There's no longer, it's no longer the case that if the judge thinks you have the better argument, but that the government's argument is reasonable, you lose. Because that's what the rule was under Chevron. And the Supreme Court has ditched that rule. It's restored judicial independence, and it's restored the ability of the legislature to control the administrative state. So hugely important decision. If we're going to have an administrative state, and frankly the view of the New Civil Liberties Alliance is that most administrative law is unlawful, but if you're going to have an administrative state, then it needs to have front-end legitimacy and back-end legitimacy. What do I mean by that? I mean that whatever the administrative state does has to be approved by Congress. It also means that whatever the administrative state does has to have judicial review on the back end by Article III judges. Those are the constitutional pillars on which between which the administrative state has to remain. And the problem with Chevron is that it got rid of both of those things. There was no congressional front-end delegation because a gap or an ambiguity is not a delegation. It's a fiction to say that it is, but Chevron allowed that to happen. So the administrative state could self-empower by looking at these gaps and ambiguities. Chevron also got rid of back-end judicial review because instead of having an independent judge look at what the administrative state did and decide whether it was the right interpretation of the statute, suddenly you had judges deferring to the executive branch's view of the law. So that's why Chevron needed to go, and that's why with the demise of Chevron, you actually have a little more legitimacy in the administrative state that remains. The Cargill case, Garland v. Cargill, is the bump stock ban case. I think that some folks have looked at this as sort of a straight-up statutory interpretation case. I think that's one way to look at it, and I think that you saw that the Supreme Court is not all textualists now, even though Justice Kagan said that, because 6 of the justices took a textualist approach here, looked at what Congress did, and decided that inert pieces of plastic aren't actually machine guns. And paid attention to the wording of the statute. So that's one holding. I think there's something more important in the case, though, which is to say the ATF doesn't have the power to retroactively interpret a criminal law in a way that creates massive new liability for 500,000 people who, when they purchased bump stocks, they were lawful. And if the case had come down the other way, if ATF were allowed to create retroactive criminal liability. That would have been a huge problem across the board. And the Solicitor General even said at oral argument, the only reason we aren't prosecuting these people now is because of prosecutorial discretion. We can actually prosecute every one of those 500,000 people who, quote unquote, lawfully owned a bump stock. I think that spooked the justices when the SG said that at oral argument. And but that's I think they reached the right result there, and look forward to Mr. Cargill getting his bump stocks back. The last case I want to talk about is the Murphy v. Missouri case. This was known as Missouri v. Biden in the Fifth Circuit, and the court did not reach the very important First Amendment issues surrounding social media censorship in this case. What the court said was that neither the states nor the individual plaintiffs, and NCLA represented the 4 of the 5 individual plaintiffs in the case, that there wasn't standing, that you hadn't proved standing. And they said this for a few different reasons, including that some of the censorship had been happening before the Biden administration really ramped up some of the directions that it was giving to the social media platforms and so forth. But I just want to stress that there was a 20,000-page record at the preliminary injunction stage in this case. And if you can't find standing on a 20,000-page record, good luck to the next person who tries to sue the government for censoring them on social media. It's going to be extremely difficult to do that. And we do have a couple other cases in the pipeline with some unique fact patterns where I think that we're going to be able to sort of navigate the gauntlet that Justice Barrett has laid out in that case. But if you're serious about stopping social media censorship, I think it's going to have to be Congress that does it, because I think the court has made it too difficult for the judiciary to police the executive branch on censorship with this case. I'm happy to answer more questions about that as well. I just want to say one other thing about jarcossy. I agree with everything that Jen said. She mentioned this, and I think it hasn't gotten enough attention in the media, so I wanted to really underscore it, which is that there are 2 holdings in the case. One of the holdings is the 7th Amendment holding that there's a jury trial right, but the other holding is that there's a right to an Article III tribunal. That's maybe even a more explosive holding than the jury trial right holding, because what that means is if you have one of these kinds of cases that would have been under the common law, or to put it in the constitutional terms, if your case is not an admiralty case or not an equity case, then you belong in an Article III tribunal, not in front of an administrative tribunal. And that's the holding of jarcossy, and it's not limited to fraud cases, and it's not limited to the SEC. That is a massive holding, and it really increases. I think it's the right holding. I think that the Constitution does empower Article III independent judiciary for precisely these reasons in these kinds of cases. But I think that that's maybe an underreported and underappreciated aspect of the jarcossy case. So I wanted to mention that as well, partly because we briefed that in our amicus brief in jarcossy.
Anytime you want to talk about the importance of Article III judges, Mark, you have my full attention. Matt, can you round us out here?
Yeah. Do I need like a fish pun?
Yes. I'll give you extra minutes for a fish pun.
Thank you. Appreciate that. So thank you for the opportunity to speak with you today. So I always enjoy speaking at the
I feel like he was fishing for extra time, but that's just.
Would you like to take my time? I don't have any fish puns. Sorry. So I'm here to offer summaries of 2 cases. The first is National Rifle Association v. Vulo, in which the NRA plausibly alleged that a financial regulator in New York coerced regulated financial firms to cut off their deals with the gun group to stop gun rights advocacy. So this occurred right around the time of the Parkland shooting. So Vulo, who was the financial regulator in New York, and then Governor Andrew Cuomo, met with insurance executives and said they would cease investigating affinity insurance arms of those companies so long as, quote, Lloyd ceased providing insurance to gun groups, especially the NRA. They also publicly requested that all insurance companies and banks in New York stop doing business with the NRA as part of a corporate social responsibility mandate. So the Second Circuit held that these were legitimate expressive activities and law enforcement activities. In a unanimous decision, the Supreme Court reversed and ruled for the NRA because Vulo was explicitly wielding her regulatory power to threaten the NRA's gun promotional expressive activities. So I don't know that the court broke much new ground here. It just sort of reiterated its arguments in Bantam that the government can't do informally what it can't do formally. I guess the sort of lesson here is if you want to coerce, don't be so tacky about it. Okay, so the second and far messier, that's the legal analysis from a public intellectual, which is a fake job, but we're all in DC, so that's fine. Okay, so the second and far messier and more interesting opinion is net choice, which was one of many cases coming to the court and that will come to the court on how to handle the quote-unquote digital public square when that public square is owned and run by private entities that claim expansive First Amendment protections from any state interference. So I'm an anti-monopolist with some focus on big tech, and this was the big case where Google, Facebook, et cetera, were trying to get out from under state regulation by claiming that everything online was expressive First Amendment activity, from social media common carriage style regulations on viewpoints to mandates for child-safe website design to surveillance restrictions. At one point in oral arguments, there was a question, well, can Uber decide not to pick you up? Is that an expressive activity? And so it's sort of everything now is online, and this was the big attempt to, or a big attempt to get out from under state regulation. So it was a pretty bold bet, and net choice lost by bringing too big a case too early without a developed record. So the Supreme Court said we're court of review, not of first view, and that's about the only clear outcome we can take from the case, that there's not a broad First Amendment shield for the internet that net choice wanted. There are some tantalizing hints of what the court might offer with future cases involving tech platforms. So the case specifically involves two laws, one passed in Texas and one passed by the state of Florida, both of which seek to regulate the content moderation policies of platforms. Florida's law limited social media platforms' ability to demonetize or otherwise restrict political candidates and journalistic outlets, and prohibited the platforms from attaching labels to user-generated content. So it also required an explanation of content moderation choices and said you couldn't change content moderation policies more than once every 30 days. It put restrictions on how they were doing content moderation. And Texas's law was similar, slightly different definitions of who would be caught. Texas's was, I think, 50 million users a month, and I think Florida's was 100 million and also had a revenue threshold. But Texas banned social media companies from removing or demoting posts based on the viewpoint expressed in the post or the viewpoint of the poster. There were some exceptions for unlawful content, election interference, things like that. But the law also required social media platforms to disclose their moderation policies, again, to notify users upon moderating their content, to create an appeals process. So Net Choice, which is a trade association for various tech platforms, brought a facial challenge which was upheld by the 11th Circuit and not by the 5th Circuit. So the decision of the Supreme Court, was simply to vacate these decisions and rule the facial challenge failed. Kagan wrote for the court, joined by Roberts, Sotomayor, Kavanaugh, and Barrett. Jackson joined, but only on the facts. Barrett wrote a concurrence. Thomas wrote a concurrence. Alito wrote a concurrence, which Thomas and Gorsuch joined. So it was one of those. It was a sprawling decision, or set of decisions. So Kagan's opinion was pretty expansive and favorable to net choice. As Judge McFadden said, this is where you could look and say tech platforms largely won the case. I think that's a reasonable view. I would say there's other reasonable views that they didn't actually get what they wanted. So she argued that regulating social media is no different than regulating newspapers, which is mostly banned by the First Amendment. Ordering a party to provide a forum for someone else's views implicates the First Amendment if the regulated party is engaged in its own expressive activity, which the access would alter. So this was, they cited a line of cases, Tornillo, Pacific Gas and Electric, Turner Broadcasting System versus the FCC, and then the Hurley case on parade organizing. And they threw cold water on the government's interest in balancing the marketplace of ideas. Now, I'm not a Supreme Court watcher. You have a very illustrious panel of Supreme Court watchers, but just reading between the lines, as we public intellectuals do, I think there were kind of 4.5 votes for Kagan's opinion, because the opinion did have a bunch of sort of odd exceptions, and they were largely drawn from Barrett's concurrence. So Kagan was trying to give a free pass to the Facebook feed and to YouTube. So the laws weren't specifically about those two entities. They were more expansive. They could have affected Venmo or Etsy, Discord, a whole bunch of other entities. Kagan mentioned the Facebook feed and YouTube and said, these are largely expressive, but didn't draw a neat line as to what kind of activity is expressive. So content moderation is a First Amendment protected activity, but algorithms, less clear. Quote, "We therefore do not deal here with feeds whose algorithms respond solely to how users act online, giving them the content they appear to want without any regard to independent content standards." What does that mean? Additionally, the court left open the ability to use competition regulation as well as laws that address quote unquote monopolistic bottlenecks. That was in one of the footnotes. And that the Turner case was about saving the business model of broadcasters. The court said that was a legitimate activity. So Thomas, Alito, and Gorsuch criticized the majority opinion for basically saying too much, but also not bothering to address a core claim from the Fifth Circuit, which is that the government has a traditional role in regulating common carriers, and digital platforms can have the characteristics of such platforms. The youngest members of the court, Jackson and Barrett, I thought had the most interesting opinions. So Jackson said the court should not be entertaining hypothetical questions about how platforms might work, but should look at how a regulated entity actually functions. And the court couldn't do that here because there's no real developed record. The injunction went into place before the law, before there was any real litigation. And Jackson just wouldn't consent to discussing whether content moderation rules around, say, the Facebook feed were constitutional. Barrett signed on to the majority opinion, but in her concurrence seemed a lot less sure about the metaphor of social media being a newspaper. She made two basic observations about why the metaphor might have problems. And the first is that the way that platforms use technology, the products they develop, could have constitutional significance. This was something that was sort of in the Kagan opinion as well. So certainly she argued when human curation or even human-directed algorithmic curation happens along editorial lines, it would be First Amendment protected expressive activity. But what if, she asks, a platform's algorithm just presents automatically to each user whatever the algorithm thinks the user will like, content similar to posts which the user previously engaged? The First Amendment implications of the laws might be different for that kind of algorithm. And what about AI, which is rapidly evolving? What if a platform owner hands the reins to an AI tool and asks it to simply remove quote-unquote hateful content? If the AI relies on large language models to determine what is hateful and should be removed, has a human being with First Amendment rights made an inherently expressive choice? In other words, technology may attenuate the connection between content moderation actions and human beings' constitutionally protected right to decide for themselves the ideas and beliefs deserving of expression, consideration, and inheritance. It was a pretty interesting broad span of opinions, but also felt a little bit like a freshman in college bull session because it was very speculative, right? So that basically saying it's a big it depends. The second objection to the newspaper metaphor, and maybe this isn't quite an objection to a newspaper metaphor, but it is an objection to the way newspapers used to be, which was relatively small, was more a managerial question about corporate rights in the age of global platforms. So this is Barrett's concurrence. Corporations, which are composed of human beings with First Amendment rights, possess First Amendment rights themselves, standard conservative orthodoxy. But foreign persons and corporations located abroad do not. Okay? So a social media's platform, foreign ownership and content, so a social media's platform, foreign ownership and control over its content moderation decisions might affect whether laws overriding those decisions trigger First Amendment scrutiny. What if the platform's corporate leadership abroad makes the policy decisions about the viewpoints and content the platform will disseminate? Would it matter that the corporation employs Americans to develop and implement content moderation algorithms if they do so at the direction of foreign executives? Courts may need to confront such questions when applying the First Amendment to certain platforms. So once again, that is a big it depends. So there's just a lot of uncertainty here because Justice Barrett is not clear about First Amendment doctrine and how it applies to the managerial structure itself. And this dynamic is less about technology or the internet and points to basic, long unresolved tensions in how conservatives think about corporate rights when firms become so powerful as to look similar in some ways to sovereigns. You start with corporations are composed of human beings and human beings have rights, so corporations have rights, but that obviously doesn't map to today's world of global publicly traded platforms like TikTok or Google or firms like BlackRock. There's an undeveloped legal theorizing about which corporations deserve rights and why, and these tech cases are bringing out this gap, this theory gap. So what seems clear, and I'll close with this, that is that on tech regulation, this is from law professor Zephyr Teachout, Jackson and Barrett are likely to be the swing votes in future cases. And I think both are open to approving certain forms of social media regulations, such as laws that prohibit addictive feeds, which are content neutral and not part of expressive activities. I don't think either believes there's a constitutional right to addict our kids to their phones, or me to my phone. You know, I always we blame kids for stuff that's actually us, right? So the process of tech regulation in the courts, I think, is going to unfold a lot. To draw an analogy, Reno v. ACLU, where they just said, boom, the Communications Decency Act doesn't apply, it's gone, and we're just going to develop the internet without public rules. I don't think it's going to look like that. It's going to be more of a bite-by-bite attempt to look at each function of a platform and whether the First Amendment is implicated. And I think that's a fairly reasonable way to understand the problem of the digital town square.
Thank you, Matt. Why don't we pick up there? I do want to get back to discussion about the administrative state and what's left of it for you legislators. But we've heard from a couple folks now about concerns about the internet, big tech. Mark, I think you said really if we want to see anything done with big tech, Congress has to do it. Do you have anything in mind? What can Congress do at this point to, if there continue to be concerns about the strength and breadth of these big tech platforms?
Yeah, I haven't given a ton of thought to what the best solution is, but one good solution that I've heard bandied about is increasing the transparency. So if the government is going to, personally, I think that if the government is asking a platform to take down lawful speech, that should not be allowed. The line that the government should be drawing is between legal speech and illegal speech. So if there's child porn on your platform, that's illegal, take it down. If there's some opinion about COVID that you don't like, but it's a perfectly lawful opinion, no, the government can't ask for that to be taken down, because when they do and it's taken down, that's abridgment of free speech. The First Amendment says no abridgment. The whole point, and that was part of my frustration with Murthy, the whole point of what the government was doing and asking the platforms to take this speech down was to reduce speech. That was the whole point, and they did it. So how is that not a violation? And technically, the court didn't say it wasn't a violation. They just said there wasn't standing. But transparency, I think, would help. That's something that Congress could do as well. If the government is going to ask the platforms to take down speech, then they should be very public about that. And there should be a public log somewhere that people can easily look at, so that if their particular thing is taken down, they know that the government asked for it to be taken down. Because guess what? That helps the traceability problem for establishing standing, and you can now show that it wasn't the platform acting on its own to take it down. It was the government asking for it to be taken down, and then you know who to sue. So that's one possibility that Congress could be helpful with.
Thanks. Thanks, Mark. So going back, I think if there is a theme from the year, it is kind of a focus on agencies, and typically, with the exception of CFPB, agencies tended to lose, at least in these big cases. What should new Congress be thinking about in terms of can they even allow agencies to have deference? How do they react to this last term? Do you want to start us out, Jen?
Well, two important things to understand about the Chevron decision is there was a constitutional question framed up. The court didn't reach that. The court essentially said that under the Administrative Procedure Act enacted in 1946, that it's very clear that the courts are assigned the job of deciding whether agencies are acting outside of legal authority. Since there's no explicit deference or thumb on the scale put in favor of agencies, that means the courts have to apply what's called de novo review, meaning they have to look at the legal question afresh. That is under the statute that Congress enacted in 1946. So I think one good point Mark made actually last week when he and I briefed 100 Senate staff with some of the other litigators in the case is that, be looking out for any minor or modest changes or things folks try to put into statutes who don't like the court's decision there to try to change it. Because if there's a statutory change to give deference, that would peel the rule back. So that's thing one. That's totally in Congress's power to determine there. how to label the standard review. Relatedly, the Administrative Procedure Act in that same section, in Section 706 within Title V, has other standards of review for other types of agency decisions. So just because courts have now said they're going to look fresh at legal questions, agencies still get a lot of deference on factual determinations, enormous deference on policy determinations. They don't get deference on whether they're using proper procedures. That's another area where courts are supposed to take a close look. But anybody who's thinking more systemically about agency activity should be aware of Section 706, which is at this point, out of my math, I guess 78 years old. So if we think the government looks different now than it did back then, maybe consider whether that structure is working well, what it needs to look like. But for now, know that it's important to write clear statutory commands, and just you can really constrain agency behavior that way, because the court's now saying we're not going to let them get the first winning crack at how to interpret the statutes that are supposed to constrain them.
So one thing, at least as it was pitched to the court, this was supposed to be, Loper Bright is supposed to be returning the function to Congress. And, Paul Clement made this whole argument that, with Chevron, it eliminates, it creates dysfunction in Congress because you don't have to speak clearly. And I think that's the thing. As a regulated party or a person who represents regulated parties, the main thing is speak clearly. I think that's awesome. But I think somewhat overlooked is there is a passage in Loper Bright that says, yeah, you can tell people to defer to agencies if you clearly charge them with like a standard that is, the kind of chancellor's foot thing, like reasonable or appropriate or things like that. But it's page 17 to 18 of the slip opinion and footnotes 5 and 6 that it talks about the kind of language you can give to agencies so that you do have to defer to them. Don't do that, because, I think it's much better to speak clearly, because it's, like in terms of notice and all of the other things that legislation does, I think that's way better. But it is at least possible. You just have to aim to do it. You won't do it through ambiguity. You won't do it through inadvertence, because so much ambiguity is unintentional, as came out at argument.
So just to put the ad law professor hat on to build on that, I totally agree with John. It's important to understand, though, that there's actually, when you use a phrase like reasonable, there's two things going on. So Chevron dealt with the law. Is reasonable, in fact, a broad term? Well, if we look at our dictionaries, we know the answer is yes. Then, because reasonable doesn't tell you exactly what to do as a policy matter, you actually shift over to a different part of Section 706, which is the arbitrary or capricious standard, which is still in the law, the APA, and the court still gives deference. So if you have a term reasonable, agencies, even under Loper Bright, will get policy deference for interpreting what reasonable means. So to John's point, if you don't want them to get that deference, you still have to clean it up in the statute, because that doesn't have anything at all to do with Chevron. There's a bifurcation. Is reasonable as a matter of law a broad term? Yes. Then you get discretion for filling in all the gaps still today under the law. So there's more work to be done.
Thank you. Yeah, go ahead.
I was just going to, and I agree with what Jen said about fact deference still being something that agencies will get. But I'll just point out that because of the Jarkissi decision, fact finding is going to be happening in Article III courts by juries a lot more frequently than it is right now. And that's a much better place to be if you're a defendant, to have fact-finding by juries rather than fact-finding by the agency itself.
Well, in adjudication.
In an adjudication, yes,
In
not in a
regulation,
rulemaking.
yeah.
John, on kind of this point about ALJs also had a rough year of it. Do you, and they've had a rough few years, actually. Do you agree that it is, well, do you see Jarkissi as having kind of a pretty minimal impact for fraud-related cases, or is this going to kick a lot more of statutes and adjudications?
I think it's a potential earthquake. I'll be interested to see what happens with it, because I think that this is potentially like a Apprendi order, where things will get shaken up, because there's a lot of I wonder what it will do for other agencies. I think potentially, everybody, any well-advised company is looking to see the sort of things that agencies are doing at that point and seeing if there's a common law analog. But I think it's potentially on the order of something like Apprendi or something. And I will say it, I talked to Mark about this at like a DC Circuit Judicial Conference 1 or 2 years ago, and he said, "Oh, I think this is going to be big," and it was like, that was big. So.
Switching gears a little bit, and we're about to open it up for questions. So if you're thinking about one, you might start formulating your question here. One of the reoccurring ideas that I've seen in the last couple of weeks is, what's happening with Justice Barrett, and is she distinguishing herself and/or distancing herself from some of the other conservative justices? Be interested in the panel's thoughts on that. Matt, you interested in starting us off?
Sure. I mean, I'm not a Supreme Court watcher. What I noticed about her opinion in Net Choice was that she is just younger, right? She's recently raising kids with the internet, so just having a different experience with the world around us. And I think that it just didn't feel, her concurrence didn't feel theoretical. Some of the other concurrences it didn't feel like they were grappling with the technology. And I want to bring up one observation about kind of where the constitutional line can be drawn, because I think it's important to note some areas where speech doesn't really capture what's going on. So there was a case where Snapchat had a feature where they allow you to share the speed limit you're going with a friend. And teenagers were using this feature and were saying, were getting into car accidents and dying because they were going really fast, right? And you could argue that this is speech, and Snap tried to claim Section 230 protections. But this stuff gets it's clearly very weird to see these kinds of, and I could go into, there's lots of examples like this, where things seem speechy, and then you get to it and it seems more like a product liability problem or some other element here. Her uncertainty, I think, was appropriate for such a broad question of give us a silver bullet for the internet, which is essentially what the case was.
Well, and I think the uncertainty may have driven the standing decision in Murthy as well. I don't think they were ready to reach the First Amendment questions.
John, anything about her emerging jurisprudence that surprised you?
So it hasn't actually surprised me. I hired her as an associate years ago, and she's always struck me as very bright, but she has her own mind. And one thing I think is kind of interesting, I pass it along because I think I'm the oldest person on the panel, that when I came into
You're
DC
not nearly old enough to be president, though. Just want you to know.
I have decades to go to make my mind up. But,
Any more cycles, you're eligible.
But I heard tell when I was a young lawyer here in the 90s that the Reagan White House would look for academics to put on the court because they figured that people had already arrived at their ideas and they weren't going to grow on the bench. And I think that the examples aren't necessarily the greatest if you look at like Posner and Easterbrook, but Scalia and was Silberman a professor? Anyway, I heard tell of that. I pass it along for whatever it's worth. But, the first couple of years, I look back I'm not a public intellectual, but I am a bean counter. And I've looked at her separate writings over the course of years. And she really started writing a lot more separately, not this term, but last term, and in very interesting ways. Like, one thing I will say, she's a very interesting writer, and she wrote a thing, I collected 5 or 6 examples, but as I say, I'm the oldest person on the panel, so I remember one, which was Biden versus Nebraska. She wrote a separate opinion on major questions doctrine that actually kind of took it down a notch and made it sound like a smaller deal than it is sometimes portrayed to be. So I think it's an interesting person. It was a big part of her separate writing, was a big part of the kind of of people describing what originalism means, which I think is kind of the most interesting thing to come out of this term as a doctrinal matter.
All right.
Can I speak
yeah.
to it? So one thing about being at counsel table at the Supreme Court is that the justices are right there. I mean, literally like 5-6 feet away. And when we were there for the Cargill case, we were on Justice Barrett's side of the bench, and so she was, literally, you can hear them breathing. They're that close to you while the argument's taking place. And very early in that argument, she said to the Solicitor General something along the lines of, "I'm sympathetic with the argument you're making, but I don't see how you get there under the statute." And I felt like right then we've won. We've got Barrett on the statutory argument. And so I do think whatever else people are criticizing her for this term, she's clearly a textualist. And we know that where her heart is on these gun cases, and you see that in something like Rahimi, although as as was said, that's a very difficult case for anyone because of the facts. But I think that the bump stock case is not the easiest factual pattern either, and she's stuck with the text on that. So I think that in cases where textualism matters, I think people will be happy with Barrett going forward.
All right, we now come to the audience participation part of the lunch. Yes, sir, please remember, as Savannah said, that questions end with a question mark.
Mark, just to go back to Cargill momentarily, because you had mentioned that the government had interpreted the National Firearms Act of 1934 to make bump stocks machine guns. That interpretation necessarily is an interpretation of the act as it existed in 1934, and so I'm wondering, any take care clause violation with the government saying we're not going to prosecute folks who owned the bump stock prior to our promulgation of this interpretation / if it turned out textually that a bump stock was a machine gun under the law, even if it might have surprised some people, any due process fair notice issues?
Yeah, absolutely. As to the latter, I think that there would have been good due process notice issues that people could have raised, but you shouldn't have to go through a prosecution in the first place. So that's, I think, where the concern would be. The other place where we were really concerned was, even if you're not prosecuted for a felony, if you're a federal firearms license owner and you've committed a felony, then you will lose your federal firearms license. And so if ATF if under this administration could have gone out to every FFL who ever sold a bump stock and said, you're a felon, we're yanking your federal firearms license. And if you don't think they would have done that, I got a bridge to sell you in Brooklyn. Because I think that's exactly where they were headed, was to pull FFLs based on the idea that selling a bump stock was a felony. So there was a lot that was going on below the surface in this case. And so I'm glad that we don't have to find out the answers to those questions. But I wanted to, on Cargill, I wanted to get back to something Jen said about the court not reaching out to take cases, because I think she was really right about that. And we had another case up at the court on the bump stock issue called Poshian, where they rescheduled it 22 times and then denied cert. There was and we watched that on your relist watch, although it was rescheduled, not relisted, but it was I think some sort of record for reschedules. Same thing with the Gatus case. They didn't grant that when it came along. So they waited until there was a circuit split, and then they granted cert when the Solicitor General asked for cert in the case, not when any of the private individuals, bump stock owners, asked for it. So I think the court was trying really hard to dodge the bump stocks case, and they weren't reaching out for this. So I just think that's another good example for what Jen was saying before.
All right. Did you have one last question? Yes. All right.
Yeah. Should Congress be concerned at all about agency action, like in the student loans, where they're deliberately trying to deny standing to regulated parties? And if so, is there any remedy that Congress should be looking at to say, how can we expand standing in some way, shape, or form?
Well, first of all, a lot of I suppose by creating like a broader injury in the statute, that'd be a way of exploring standing. But just so everybody understands as a basic matter, when we talk about standing, what that means is it's actually what we call a jurisdictional limitation. So the court doesn't actually have power to hear it, and it's for a good constitutional reason. And we actually want the courts to be somewhat circumspect, because reason Article 3 doesn't more dramatically refashion policy in this country is because the judges are supposed to be resolving only cases or controversies. So there actually has to be a concrete dispute between two parties. And so it is the case that
One of whom was injured by the other.
One of whom was injured by the other. Well, that's how the dispute would be, because there's some disagreement because one person's faced negative harm. And so in a certain sense, sometimes there's a lack of injury because the government's trying to get these cases framed up in a way where one party wasn't actually harmed. But in the student loan case, people did find standing. I think it's more about making sure, maybe dealing with it on the ripeness or final agency action front, different than standing. The government was trying to get away in the student loan case with not reaching so-called final determinations about what action it was going to take, but sort of putting up policy statements or taking directions that everybody knew it was going to lead to a certain type of outcome or resolution. And so I suppose the language could be tighter in terms of making agency action more reviewable more quickly. And actually, another one of the decisions issued at the end of the term helps that we didn't talk about today. And why am I forgetting the name?
Corner post?
Corner Post. Actually, so I'll give him a shout out. Ellie Nachmani, who's sitting over there, and I are working on an article dealing with this case and others. So we will opine publicly on this in the near future. But that's actually a case where Justice Barrett's opinion expands and makes it a little bit easier based on statutory meaning to actually to challenge agency action.
All right, ladies and gentlemen, please join me in thanking our panel for this excellent discussion.